With the jury seated in Delaware, opening statements in Hunter Biden's gun charges trial got underway this morning. We also heard from the first witness as the prosecution put an FBI agent on the stand to testify about Biden's infamous laptop. My colleague Ryan Nobles has more.
Tonight, the prosecution kicking off their case against the son of the president with one simple message to the jury. No one is above the law. In opening arguments, prosecutor Derek Hines saying Hunter Biden was a user of crack and a drug addict. He chose to lie on a government form about his drug use when he purchased a .38 caliber handgun. No one is allowed to lie on a federal form like that, even Hunter Biden, he said. Hines pointing to the defendant's own words in his own voice.
Mainly, however, we just planted ourselves on the couch and smoked a ton of crack.
Hines playing these audio clips from Hunter Biden's memoir for the jury.
By now, I possessed a new superpower, the ability to find crack in any town at any time, no matter how unfamiliar the terrain.
First Lady Jill Biden, his wife Melissa, and sister Ashley were in court, sitting together while the excerpts played, visibly shaken and embracing each other. Hunter Biden is charged with 3 counts related to allegedly purchasing and possessing a gun while using narcotics, and faces prison time if convicted. But defense attorney Abby Lowell telling the jury today, you will see that he is not guilty. He said that Hunter Biden did not knowingly lie on the form, arguing that during that narrow window of time, Biden was not acting like, quote, someone who was smoking crack every 20 minutes. Late today, the first prosecution witness, an FBI agent, testifying about Hunter Biden's laptop, telling jurors investigators found text messages detailing his interactions with drug dealers around the time he made the gun purchase.
Former Manhattan prosecutor Jeremy Saland is back with us. What stuck out to you in this first day of testimony?
A few things stuck out, and I want to just read from the prosecution's opening that was briefly mentioned. No one is above the law. It doesn't matter who you are, what your name is, because in this country, the law applies to everyone equally. That law makes no distinction between Donald Trump, Hunter Biden, and anybody else. That's fair and that's right, but I would argue that when you look at these two cases and you look at the argument that you're hearing from people saying that the weaponization of the justice system, Hunter Biden is being prosecuted for a crime that you rarely will see as a top charge out of all the gun cases that are charged. And how are they getting there in part? They're taking the person who is the seller, who actually took the wrong ID. He didn't take a driver's license. He used a passport, which is not permissible. And he is now cooperating, if you will, and testifying against Hunter Biden. Why would you want to go after Hunter Biden and not the company or the store that is unlawfully and improperly selling firearms? There's so much about this that really is off, and it's absolutely, or it seems to be, far more born from politics than anyone could accuse the Manhattan case.
What do you think of each side's strategy so far?
I think that the defense is doing a good job in terms of their opening and making it clear that what is an addiction when you're an addict? And that's part of the statute. That's part of the violation. He's a user and addicted to. And there was a great point made in opening by Lowell, I believe it was. When you're in AA, you're an addict. You may not be using for years and years and years or ever use again, but you're always a recovering addict. So it's a vague issue. It's what does that mean? Knowingly, was he an addict at that time? Was he using at that time? On the flip, I thought the prosecution did what they needed to do when they started with that first witness. And what was that? Well, you're hearing from his own voice, meaning Hunter Biden. You're hearing from his books that he was an addict and an abuser and a user of drugs.
So you think it's important, you think it's a good strategy, because it seems like the defense is spending a lot of time focusing on the fact that he's an addict.
Yeah, I think that's where you're going to ultimately have to go, because you're not going to dispute that you filled it out. You have to admit that. You can't deny that. But what was your situation? Were you an addict at the time as required by the statute? That's a vague statute and constitutionally potentially not proper. It's in fact, similar statutes have been challenged. Most recently, I believe it was the Fifth Circuit out of Louisiana about marijuana use. So it's a really interesting statute. I will add this. Marijuana is a controlled substance on the federal level. It may be legal, for example, here in New York, but it's not on the federal level. So if someone is addicted to marijuana, if you wake and bake, if you're using it 3 times a day, does that mean in middle America, in these Republican districts, those people should all be prosecuted? Clearly, there's an issue here.
So where do you see this ultimately going, this trial?
It's going to be a hard lift for the defense. I think it's going to be one where you're going to keep on hammering that he's not an addict. Pardon me. In that moment, he was not an addict, or he didn't believe he was an addict, and he did not unlawfully or knowingly fill out that form in a means by which he was lying. In that moment, he was okay. So I think that's going to be the biggest.
I'm sorry, you said it's going to be a heavy lift for the defense. Do you mean it's going to be a heavy lift for the prosecution?
I think it's a much heavier lift from the defense because you're playing and parsing with those words of addicts. Are you now an addict? When you actually fill this out, because that's the moment in time. It's not whether you have been 6 months or 2 days ago or 5 days ago or when you last used drugs. Are you an addict? So it's a vague issue. It's a vague concern. Well, not a vague concern. It's a very real concern that the statute and the paperwork was not clear. That's the argument and the angle they're going to have to go with.